Welcome back to Rethinking Politics. We're glad to have you guys here with us for episode 79. Today we are going to be talking about the Sandy Hook settlement with Remington and parents and survivors of the Sandy Hook shooting. This settlement happened just last week, just a few days ago. So let me tell you a little bit of history first. So everyone's familiar with the Sandy Hook school shooting. Took place in 2012 in Connecticut. Was a mass murder of 26 people. And, you know, it was I don't even know what term you use, but you know, it was a single gunman who had a handgun. He may have had a .22 rifle, and for this case, the important part is he had an AR-15 style assault rifle that was manufactured, maybe not by Remington, but by one of their subsidiaries. You know, how the companies actually shake down is a little complicated. But he had an AR-15 made by Remington that he used as part of his shooting to kill many, many people. Soon thereafter, a group of parents and survivors from the Sandy Hook shooting sued Remington, which is, you know, to be expected. And that lawsuit has just now been resolved. So the first question is, well, why did it take, you know, almost a decade for this case to get resolved? And the answer is actually rather simple. It's because in 2005, the United States Congress passed a law called the Protection of Lawful Commerce in Arms Act, which was this blanket immunity that barred civil suits against the gun industry with a few exceptions. There were actually 6 exceptions in the law, and this case took advantage of one of those exceptions. And the exception that they took was the third one, which is, I'll read a quick summary here of it. An action in which a manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to the sale or marketing of the product, and the violation was a proximate cause of the harm for which relief is sought, which is legalese for saying that if the gun manufacturer knowingly violated a state or federal law that has to do with the sale or the marketing of a gun, then they can be sued. And in this case, the argument was made that they violated a Connecticut law that dealt with unlawful marketing by companies, not just firearms manufacturers, but all companies. And it's actually an interesting case. It's the Unfair Trade Practices Act that was enacted in Connecticut. And so the argument is that they had unfair or illegal marketing practices. So what were those marketing practices? So the argument is made by the plaintiff that they were promoting unlawful military use of the rifle by civilians. And in this case, what they're talking about is the advertising that Remington did, things like "Consider Your Man Card Reissued," that was targeted in an ad that ran in video games and other things, and a couple other slogans like that, like "Opposition bow down, you are single-handedly outmatched," arguing that these statements and others were actually promoting or encouraging unlawful military use of the rifle. In other words, someone could see that ad, buy an AR-15, and shoot people that they considered their opposition, and that was in some way encouraged by Remington.
Which is how this is going to waive the liability you mentioned.
Yes, so,
how this is going to make them.
Part of why it took so long is because before it could really come to trial, it had to be cleared past this law. Before there could even be a lawsuit, someone had to rule on this law. So it eventually went to the Connecticut Supreme Court, where they ruled that because of this Connecticut law, it could proceed, the civil action could proceed. It was then appealed all the way to the Supreme Court, and the Supreme Court refused to hear it. In other words, the Supreme Court agreed with the Connecticut Supreme Court enough to not consider it. They weren't even considering overturning it. They're like, this makes sense. it goes back to you, which meant that the Connecticut Supreme Court ruling held, and then it could go back, and so it went back, and then eventually Remington settled for $73 million and the release of internal documents, which is an unusual settlement. Often these settlements are behind closed doors, and the amount is not disclosed. That's part of the agreement. This was a very unusual settlement in that the company gave a lot more than companies normally do. The first thing is that it was public. Everyone knows the exact amount that they settled for. And the second thing is that part of the agreement was that they had to release a ton of internal documents like they would have to do if it went to trial. And I think the idea is that these people, these parents and these survivors weren't just interested. They definitely weren't just interested in the money. They were interested in what happened and why it happened and how it could be prevented going forward. And so they wanted that publicity and they wanted that transparency that you get from a court case, even if there wasn't a court case. And so that was the final settlement, which happened just recently. And the $73 million, that amount was actually because that was basically all the money that was available. Remington actually ended up going bankrupt. And you had these insurance companies that ended up handling the case, and that was the amount of money they had to work with, and so that's what they took. In other words, it's a pretty clear-cut victory in this case, for the Sandy Hook survivors and parents. This was a clear-cut victory. They won the case, even though it didn't go to trial in that sense. But more importantly, they won the legal case beforehand. And they got all those documents released, which makes it public and not just some hushed up, settlement behind closed doors.
Right. There's so many interesting pieces here. If you're listening to this, you're not familiar with these kind of cases. There's 3 specifically. No, Dan, not so many. 3. The way that, at the level of practice, is this sufficient? Given the standards that you indicated of you can't, obviously an advertisement can't tell someone to go do something illegal. Mm-hmm. That makes a lot of sense. A religion can't do that, which is another group that often has a variety of exceptions, right? If your religion is advocating stealing or hurting people, it will be stopped. And that's true in every state. And that's been true from the founding. That was never the case. Locke argues about this. Locke is like, no, if there's a general rule, like no theft, no murder, and all these things, these kind of general crimes, which obviously going in a school shooting certainly falls under murder and these other general laws, then to encourage that is illegal and is contrary to whatever protections you may think you have. But it's interesting that you mentioned some of the lines. Those are not lines we're drawing. Those are lines that the case and people writing about the case mentioned as indicative of Remington encouraging people to engage in these kind of actions. And now, obviously, they're not arguing that Remington is the reason that he did this. Mm-hmm. They don't have to prove that Remington was the key part, that he saw these advertisements and was like, I now know what I need to do with my life. I need to go shoot up the school.
It's worth noting, Dan, that this is just one part of their suit. Their suit had many, many claims against Remington that basically right. So I would disagree with that claim that they don't think Remington is wholly responsible. I would argue that they do believe Remington is wholly responsible because Remington made the firearm. And their belief and their argument is that if the firearm had never been made, it never could have been used. But their argument, because one of their arguments in the case that the Connecticut Supreme Court, dismisses out of hand, is that Remington made the rifle and therefore they're responsible for the crime. They're like, no, that's not how this works. Yeah. Yes. People make products all the time and they're not responsible for the misuse of those products by individuals. A great example of this would be, the the man who drove his SUV into the crowd, just a few months ago.
Mm-hmm.
The manufacturer of that SUV shouldn't have any responsibility for that act. You know what I mean? Because there was no negligence there. They made a vehicle that was designed to drive, but it wasn't designed to kill people, but someone misused it.
Yes. And you could also see how if what they're advertising was, this is even better than a weapon. Look at how many people you can.
Well, yeah.
There's an advertisement of them running through a crowd of dummies.
No, and that would be a grotesque, but
that's not funny. That's terrible. I shouldn't be laughing.
It would be an example, yes, of how that would be a clear violation of the law. But here it's definitely a little bit murkier. But my point is that there are definitely a lot of gun control advocates who would argue that there is no legitimate use for an assault rifle. That, that if you want to go hunting, you don't need a high magazine capacity. You don't need the high magazine capacity. You don't need maybe even semi-automatic capability, which means that every time you pull the trigger, it fires a new round. You can just have a bolt-action hunting rifle and be fine. If you want to go shooting for fun at a range, then why don't you just get a little .22? You don't need an AR-15 for any of these legitimate optics purposes.
And grips.
Exactly. Therefore, the only purpose of an AR-15 is to kill other human beings, and therefore, simply creating the AR-15 is acknowledging the crime,
Yes, yeah. Is advocating
is allowing for them to
advertising for
that, that it's not misuse because the clear purpose of the AR-15 is to kill.
Yes, and these arguments, as you indicated, were thrown out and have been thus far systematically thrown out in most states. Mm-hmm. Probably all states, but I'll commit to most at this point.
And the evidence for that is very clear because the AR-15 is probably, and I don't have enough data on this, but it's probably the most commonly owned rifle in the United States right now. I mean, there are so many AR-15s. If you go to any gun store, they will have not just one AR-15, but a whole slew of different AR-15s that you can purchase. And, ranging from very cheap to super expensive. I know many, many people who own AR-15s and who do go shoot with them at the firing range. Some people even do hunt with an AR-15 and don't commit crimes with them on a regular basis. When you've got something like 50 million AR-15s in the hands of Americans, and not the vast majority, but the tiniest fraction of those Americans misuse those AR-15s for illegal acts, therefore disproving the argument that the only purpose is an illegal act, because it would mean that the vast, vast majority of those owners have an illegal purpose but are simply failing to carry it out,
Yeah. Yeah, which would be a strange argument. I guess that, and if you did, even if a court sustained, a particular court, a particular state, Supreme Court even sustained the argument that by creating such a weapon, you have endorsed or advocated or encouraged or enabled violence, and thus are liable, the Supreme Court of the United States would slap it down. At least at this point, they still would. It's just too clearly, the Second Amendment is just too clearly not limited to hunting and things like that. Mm-hmm. And so that is still the Supreme Court standard at this point, and likely to remain so for some time, given the current majority. But even without that, it might remain so. It's just too clear the intention in some of these cases. You can argue variety of things around it, but anyway.
But there's a couple specific parts of this case that are really interesting. And one of the ones that I want to talk about is the Protection of Lawful Commerce in Arms Act, the 2005 immunity law that was passed. Because obviously, any gun control advocate is going to hate that law. If you don't hate that law, then you're not really a gun control advocate. Because in strict terms,
it's what protects them.
In strict terms, it is unfair, right? This law is saying that these gun manufacturers, unlike most other industries, are going to get special protections from litigation. That if you manufacture, a lock-picking set, and that lockpicking set gets used by a criminal, it's going to be much easier for someone to sue you potentially than it is for if someone takes a gun that you manufacture and misuses it by murdering someone with it. You know what I mean? So you look at that disparity and you say, why? Why is this disparity here? And and that's a good question. The answer is, of course, there are a lot of NRA advocates and a large number of lobbyists who protect these gun industries. I mean, that's the short answer. It's not some principled stand. No, it's because they spent the money and their resources to get this protection, which is something that personally I'm not crazy about. You know what I mean? This law is not my favorite. It's something that makes me a little bit uncomfortable.
The need for an exception in the law and how cases are handled regarding an industry is a bad sign. Mm-hmm. And we've talked about it in relation to other things. Walmart has laws on the book. There are laws on the United States books that apply specifically by name to Walmart. That's a bad sign. Mm-hmm. That is a bad sign. You do not want rules of some kind applying to one group and other rules applying to other groups. By definition, it's unjust. It's unfair, right? It's not level. It's not consistent. It's not. And that's a good example, because just like the fact that I don't like those laws that Walmart's lobbyists get put in place to protect Walmart, I don't like, the idea that, this immunity for the gun industry. But just like Walmart, I understand why these companies are doing it, because in this world of litigation, it's very hard for companies to survive without protection, especially large companies that have a large amount of money. You know what I mean? When you have a mom and pop shop, you often don't have the same protections as Walmart. But guess what? Your employees or your customers are much less likely to sue you because they know you don't have a ton of money. You know what I mean? They know you don't have massive, liability insurance. They may still sue you. Like small companies do get sued on a regular basis, and they often do have to have some kind of insurance. But my point is that it's not on the same scope that a company like Walmart has. You know what I mean? I mean, I think of Amazon and all the crazy stories you hear about mistreatment by their employees, and as someone who's never worked at Amazon, of their employees by
mistreatment of their employees by Amazon, and I don't know if that's true or not. What I do know is that when you have a company that large with that much public attention, any potential is going to be exploited. You know what I mean? Even if it's just one facility that has the problems, that could easily lead to a class action lawsuit because of their public image and because of their massive wealth,
prosperity,
that they can be sued for millions. Remington was, even after going bankrupt, still able to be sued for $73 million.
Yeah, yes, that's their death throes financially are still worth $73 million.
Yeah, exactly.
Yes. As a general rule, I sat in a meeting. This was a meeting in the Utah State Legislature. I was in a committee meeting where most of these, if you've been to a committee meeting at a legislative body, they're not the most exciting thing in the world.
They're fascinating because this is where decisions are made. But
a lot happens there. Yes, much more happens there than inside the actual full body meeting together. So this company comes in and they're presenting to this committee. I don't remember the particular committee. Something to do with employment, obviously. And the company proceeds to spend 20, maybe even as much as 30 minutes explaining why these provisions in the Utah state law that gave them various financial benefits should continue because they were sunsetting. The sunset clause is when you add to a law a timer. You go, this expires in this year, or it has to be reconsidered every 2 years or something like that. There's a point where it has to go before the legislature again, or it disappears. So they come in and frankly, the whole thing was disgusting. not because anybody there was particularly vile, but they're explaining how
Were people
they
there
employ...
somewhat vile?
Some of them were,
Okay,
yes.
continue. It was just...
Yeah. Luckily, state legislators aren't quite as icky as national legislature, but
they're
still icky.
It's icky in its own way.
It is. And this was one of those moments. So they explained that they are providing a lot of jobs, and they had the numbers, and they're making this much profit, and they're donating this to the community, and they're trying to be environmentally conscientious, and it was like watching someone. This is what I imagine it looked like when someone would go and try and get a charter from the king. We're like, I need a financial favor, and you have all the power, and I'm not sure what you want me to say, but I'll say it. Right? I'm not sure what you're looking for from us, so they just kind of scattershot. And partway through, one of the legislators who I really liked interrupts, and he's like, why are we doing this? Clearly, we should just renew this and move on. And I was like, wait, what? And then what you find out is that most sizable businesses in a state have these kind of cutouts. And if you're an international business like Walmart, you've got it at the national level. You have your own negotiated tax code in a lot of ways, tax benefits and costs. You have your own special subsidies, special exceptions to the rules. You have your own, and all of this in the name of job creation. And the whole thing undermines the very concept that we are ruled by laws if those laws are negotiated on a case-by-case basis.
Yeah, because that's not how laws work. At that point...
That's not the idea.
At that point, It's not a just law in any way, shape, or form. Just like...
Yeah, it's a deal.
Yeah, exactly. Just like having immunity for one industry and not the others is not a just law.
Yes. You can see why there might be exceptions in some cases, but I don't think I have yet seen an exception in law where I didn't think either this exception is unjust or the law at a deeper level in this sphere is corrupted. And so that you have to have justice, make an exception, right? And and neither of those are a good sign. If you went systematically and looked at exceptions to the law where industries or companies are individually answered, and you tried to address that problem in the law, not only would our tax code and all of our laws get significantly shorter, you would have a way better system and a much more fair and just system where companies aren't going to places where they're getting the best government deal, which is not how this should be working.
No, and that's a fair point, that when I say that this immunity is unjust, I don't mean because what it's creating is unjust, but rather the injustice of partial...
Of having to have an exception.
Yeah, exactly. It's a mess. You know what I mean? It's just like if Walmart is able to avoid, unjust laws, but the rest of us aren't, I would consider that unjust, even though what Walmart itself is doing isn't unjust.
Isn't necessarily bad, but there's still something unjust.
There's still an injustice.
Yeah. You should not have exceptions like this. And if you decide that your job as a government legislator is to make the world as effective as possible, then you believe you have the ability to see which of these should succeed and which should fail. You're picking winners and choosers, winners and losers, that kind of thing. Which I think leaves a bad taste in pretty much everyone's mouth. Even if, you don't have to be a free market advocate to say whatever the laws are, they should apply equally. And if the laws want to be strict against business or they want to be loose against business, everyone should be playing by the same rules. And I think this is one of those cases where something is afoot, and you can tell because there's an exception. And that should make you leery. That should make people upset. And a lot of people assume that the problem is that they're getting a privilege rather than getting justice.
Yeah, and so what's afoot? What underlying issue? What deep corruption is taking place here is actually relatively simple, and it's just the way that liability and litigation law has developed. Because, first of all, it's very complicated and it's very messy. And one of the reasons is because it's gotten bad. And once it started to get bad, companies started carving out positions for themselves. So there really is no clean civil liability system that we have in the United States. You know, it's a giant mess because you'll have companies that are behind shields upon shields upon shields, while other companies are operating out in the open and are therefore exposed to the devastating litigation that can happen. And then there are lots of cases of that kind of devastating litigation. I mean, everyone's heard, you know, the ridiculous stories. Like, for example, there was a case years and years ago where someone was trying to break into someone's house, and they got in through the garage. The garage door closed behind them, and the garage door opener wasn't working or something like that, and they got stuck in the garage for like 16 hours. You know, the family was gone, and they just couldn't get out of the garage, and they were trapped because the door to the home was locked, and they couldn't get out the garage door for whatever reason. And that person sued the homeowners for having this unsafe setup in their garage and harming this person who was trying to break into their home. And cases like that, and in some cases like this, these ridiculous cases, people win. You know, criminals have, while committing criminal acts, sued businesses and individuals and won before, which is an example of how crazy this system can be. But
yeah, I'm reminded while you're
go.
pausing there for a second. I remember hearing about this case as a kid where the woman gets, was it coffee, hot chocolate from McDonald's, and spills it on herself and actually gets burned. Actually has, not significant burns, but at least superficial burns.
Yeah. I mean, it's pretty easy to get a 1st-degree burn. It doesn't have to be that hot.
Yeah. Yeah. And whatever however bad the burn was, I mean, I guess how bad the burn does matter.
Absolutely.
If she's handed liquid that is like melting the cup, then that's very different than if she's handed something that's pretty hot.
Yes, the same temperature as hot coffee or hot chocolate, which is not unusual. It's a normal occurrence.
It was boiling not too far in the distant past. Which is what it's supposed to be. But what happens is, there's this lawsuit that goes through and McDonald's is sued for a significant amount of money. I don't remember how much, but as a kid, it seemed like a lot. Probably wasn't that much, but she does win. And McDonald's adjusts what exactly? Well, there are now warnings on the coffee cups that say they're hot. And now it's your fault if you spill it on you, because now you know when you order coffee or hot chocolate that it's probably hot enough that it might be uncomfortable or even harmful to you if you spill it on you. Right? Is this the world we want to live?
No, and that's a great example of how litigation has changed, is that in the past, it was a common sense principle that if generally people understood what was going on and you didn't, it was your responsibility. That when you go out into the world and you order coffee and it's hot, that's not McDonald's fault. That's your fault. But what's happened is the onus, the responsibility has shifted. That now companies have to make sure that even the least well-informed person, or the person with literally zero common sense, has every opportunity to understand what's going on before purchasing their product. And if that person doesn't understand, it's the company's fault. And that's why we live in a world today where everything has warning labels. Dan, Dan actually has, it's not an AR-15, but it's close. So it has to have quite a few warning labels. You want to show them what you have over there that's so dangerous?
Yeah, all told, it has 17 things. 3 of them, they're actual safety precautions, and 14 additional precautions.
So, 3 are actual warnings, and the rest are caution.
3 are warnings.
But caution statements are still warnings. It's just a different category.
This is, for those of you that can't see it, it's small. It's about as long as my palm.
It looks like
longer,
a remote.
Maybe 6 inches. Looks like a TV remote, but it's a little oddly shaped. It's an infrared temperature.
Yeah, it's a forehead thermometer.
Right. No contact thing. It's a really nice one. I don't even know. Someone got it for us recently. It is an amazing product. I'm not going to tell you what it is unless this company decides to start sending me money.
They're not going to.
The point is,
not once you go through all of these warnings.
There are no stray pieces that come off. You got a battery thing on the back you can open up, right? It's going to take batteries. It doesn't like recharge itself. You put the batteries in. There you go. This is the device. Here are the 3 warnings. Ready? Use of this thermometer is not intended as a substitute for consultation with your physician. Please consult your doctor if you have any doubt about the temperature reading. Can you imagine the cases that must have happened for this to be necessary to put this on this paper? No one, I guarantee you, the company didn't think, the first thermometer maker never thought that they were going to be sued because someone didn't go to the doctor.
Because they took their temperature instead and said, now there's, now I have, covered all avenues. I'm safe.
Right. And as a side note, it's worth noting that has anyone in their life read these? Probably not. Not until me.
Not until you right
this
now.
Morning. Not until we were making this episode. Here's the second one. Keep the thermometer out of reach of children. It looks like a TV remote. Where do you leave your TV remote? For accidental swallowing of the battery or other components, please contact emergency services immediately.
For the record, Dan, I bet TV remotes have this same thing, that really what we should be doing is leaving our TV remotes in a locked cabinet 8 feet up.
Yeah, what are you swallowing here? Seriously, you'd have to smash it against the wall before you got a piece that a child could swallow.
Or you open up the battery compartment. I'm not sure how difficult it is.
And swallow a battery directly. But again, a battery, how big is this toddler's mouth? This double A battery.
No, yeah, guys.
Battery, and here's the third one. Batteries must not be thrown into an open fire or short-circuited. What's remarkable about this is that none of these really have anything to do with this device. We've got, you should see a doctor if you're ill. You should not throw batteries in fires, right? This is not a battery.
And your kid should not swallow batteries.
And your kid should not eat things that aren't good for them.
Batteries are dangerous for children to eat, but I can also tell you,
as most chunks of metal.
Yes,
not to mention the battery acid, right?
That those things. Those last 2 would apply to anything that has a battery. I want to read about the case where someone had a bunch of batteries, and they're like, "What do we do with these to get rid of them?" I'm like, "Oh, we'll just chuck them in the fire," and thus the case is born.
Yeah, and the point is not, people sometimes go silly and they go overboard on caution. The point is we've really missed the boat somewhere along the line if a company can be sued for not having these kind of things. Somewhere along the line we took a really wrong turn on who's responsible for your life. Mm-hmm. And making
or your child's
good
life.
choices.
You know what I mean? That you're responsible for knowing what can harm your child and taking reasonable steps to prevent it.
And again, if they make a piece on there and they're like, we recommend having your child suck on this, or something like that, that's different. Mm-hmm. You could show actual culpability. Mm-hmm. But it's the existence of this thing. This is the least dangerous object in my house. I guess having a battery in there elevates it above something that looks like this that doesn't have a battery. But again, batteries generally don't spontaneously combust and things, and that warning wasn't on there anyway. But it's a weird world. At some point we decided. So knowing that, is it any shock that for you to sell guns, you have to be more protected than this? Mm-hmm. Mm-hmm. A gun explodes. There's a part of the gun that hits with a little hammer and triggers an explosion. Mm-hmm. The firing pin and triggers an actual explosion that then fires a projectile that is designed to penetrate hard targets, right? Mm-hmm. And could. of course, for that to exist, you have to have something. There's a comedian who jokes about, some of you may have heard of Brian Regan. He talks about what it would be like to patent and get approved an ironing board in today's world. Where he's like, it's designed to tip over, and we're going to put a hot iron on
with
top
boiling water inside.
With boiling water inside, right? Right. He's not wrong that you probably couldn't get that approved at this point. Right? If it weren't like a common household item from another age, there's no way. There's no way. It would have to have legal exceptions.
Sorry, I'm just thinking of his joke, because he's talking about the guy presenting it, and he's like, well, we've got it right about here at child height, so they can run into it, knock it over, and the iron can fall on their head.
That's right.
We've got the boiling water for burns.
Yeah.
We've got this mechanism that's impossible to get up, and that's often likely to collapse. And if that's not enough, we've also got the
precariously
cord,
high center of gravity.
Yeah, so it'll tip over. And then we've also got this cord that runs right above the ground, so we can get the toddlers involved.
That's right. They can pull it off onto themselves. Mm-hmm. No, in one end designed for puncture wounds, and another for blunt trauma, with enough weight for blunt force trauma. Yeah. Yeah. It looks like it's designed to injure children and to be dangerous to everyone in the house. And to be fair, I've burned myself with an iron more than once.
You have?
Just using it.
I was going to make the comment that as someone who's had a very old iron that doesn't meet any of the modern safety standards, I'm sure, and a very old ironing board had no issues at all, and you just treat it with a little bit of common sense, and it was no issue. But here you are saying, no, Dan's burned himself half a dozen times. He needs the labels.
My body's covered in scars from ironing shirts.
Both physical and psychological.
I didn't read the warning that you were supposed to take the shirt off before you iron it. I tried to sue them already, and no, they had
a warning label.
Prepared.
Yeah, you should have read that.
Yeah,
I could see that. I could see a warning label that says, "Make sure you remove the shirt before ironing."
I'm pretty sure it's on there. I don't think I came up with that on the fly. I'm pretty sure I've seen that. Now, like I said, I think it's really important not to. The point we were making is not there shouldn't be safety precautions. There should not be safety warnings. There should not be instructions, and it should be a crazy free-for-all where you make whatever you want with no consequences, right? That's not what we're saying. But we have really gone to an extreme here. And the extreme is somewhere along the way we decided, it was Brad stated it, that it is the company's fault.
Well, see, and I would even go beyond that, Dan, because I would say it's actually worse than that. Because what we've done is create a situation where, without special protections, any company is liable for all sorts of lawsuits because they hold the responsibility. Therefore, companies, especially large companies, have gone out of their way to protect themselves, which means sometimes even when you have a legitimate claim against that company, you don't have the ability to sue them because of special protections like this one. And so we've actually created a world where the default is that companies are responsible, and the result is companies go out of their way to protect themselves using the instrument of government, and the end result is it's a hodgepodge where sometimes it's super easy to sue companies, and other times it's impossible. And no matter, even if you have the most legitimate case in the world, it's not about whether or not your case is legitimate. It's about the minutia of the laws. And that is a truly horrible system for everyone.
Yeah. Yeah, it's a world where we've rejected any reasonable standard of what it works, and it's just negotiated terms with the government.
Yeah, exactly. It's not about common sense. It's not about a common law system that's built off of reasonable expectations and things like that.
Right. That you could come to intuitively, right? You could think about it and you could go, I probably can sue them here because they clearly made a serious error that's dangerous and
which does happen, and lawsuits used to be a great avenue of correcting that.
Yes. And now product liability is a is only one limited sphere of this. Whereas, like you were saying, some of the barriers between them and consequences, things like, we've mentioned before, things like the corporate shell, being able to have this entity between you and the customers, you and your decisions that protects you and that can be sued. I mean, the reason a corporation is a type of LLC, essentially a limited liability corporation, right? It's the point.
Title.
The point was to protect them, and the reason we chose to protect them initially, when this device was come up with, was designed legally. This was a privilege granted to favored industries that we thought we wanted so badly to be successful that we were willing to protect them as a society. Right? It was, at one point, it was a choice.
Yeah, just
to grant
almost
a privilege.
like this immunity law.
Right. It was a choice to grant a specific privilege to a specific group of people. And at this point, it is the normal standard for business. Now, you can still do other forms, but this is ubiquitous. And it's a privilege of protection from liability in cases where common sense would say, and where general legal standards would say, they should not have been protected. They should be subject to penalties. So how does this relate to this case, Brad? What do you think on this particular case?
Well, as we've already covered, I don't think that there should be this immunity law. I think that without this law in place, there would be a huge reduction in the manufacturing of firearms because this is the protection they're relying on. That Walmart has their protections and these companies rely on this law. And so they would need to reorganize their protections before they could continue manufacturing weapons. But if you got rid of this law, they would come up with other protections. You know what I mean? You know, individual companies would find their own loopholes and their own extensions to get the protection that basically every other major company has, because that's how the system works. And so the idea that if we just get rid of this one law, we'll fix the problem in terms of gun manufacturers, I don't think that's the case. That's one part of it.
You've got to go deeper than that.
That's one part of it.
I think that's accurate.
The other part of it, about the marketing and the loophole that was found here, is an example of how the legal system is out of whack. Because to argue that because they said, consider your man card reissued, that they were culpable for the Sandy Hook shootings is, I think, it's a reach. You know what I mean? That it's a stretch.
Oh, yes.
A very large stretch. And the reason they made that stretch is because there's the legal grounds for it. Like I said, the people who are making this argument are not making it because they believe that the marketing is the problem. They're making the argument because they believe that they shouldn't be making these guns at all, but they don't have, the legal standing for that.
They're looking for the legal standing.
So they're looking for any legal standing they can find, and they happen to find this one because of the way the laws are set up. And I think I don't think it's really legitimate. I don't think you can make the argument in good faith, just talking to each other. I know people make arguments all the time in cases and make arguments when they're, up there having a political debate because they're getting paid to defend their side. That's different. But I'm saying a good faith argument between you and me to argue that when Remington made those ads, their intention was to endorse criminal violence is crazy. To think that that's what they were thinking, and to argue that makes them responsible for the Sandy Hook shooting, I just don't buy it. I really don't.
Do you think it's a reasonable conclusion if you're watching it to say, okay, maybe they didn't intend to, but these advertisements, let me pull up some of the terms they used, because we thought this was odd. So they promoted the particular weapon for civilians. I'm reading from a summary of the legal brief on Justia.
Yeah, on the Connecticut Supreme Court ruling, right?
Yeah, it's a formal. That's right. The Supreme Court of Connecticut.
Yeah, and
correct.
By the way, if you guys are wondering, the case is Soto versus Bushmaster Firearms International LLC.
Yeah, we'll include the link to the Jostia, which has the summary that I'm drawing from here, and also the actual complete case if you want to look at, really dig into it. Of course, there's also lots of news articles about it and things you can find. So this is one of the interesting ways of framing it. So the Remington promoted the particular weapon for civilians to use to carry out offensive military-style combat missions. And that is, as Brad indicated, that by encouraging that, they're encouraging them to do something illegal. Right? They're encouraging them to use these weapons in an offensive military-style combat mission, some kind of offensive being attack, right?
Mm-hmm.
And aggressive as opposed to defensive, as opposed to self-defense or something like that. And that this makes them culpable of maybe not of the Sandy Hook shooting, but certainly culpable of violating the law by encouraging illegal action.
And by the way, a lot of people who are in favor of gun control or who are anti-assault rifle will be like, yeah, that makes sense. And I want to pose the theory that the reason that makes sense is primarily because you believe assault rifles don't have a legitimate place in society, because that kind of advertising is not that unusual. Like, one of my favorite advertising things is car advertisements. One of my favorite ads I ever saw was quite a few years ago. I want to say it was like 10 years ago or so, but it was for, I believe it was the Lamborghini Aventador, and it was an incredible ad. And involved this bright orange Lamborghini. It's a beautiful car. At least I think so. You may think it's ugly, and that's not the point.
But it is the point, Brad. It's no, just kidding.
But they have this ad where this person is driving this car across this huge flat, like almost desert. It reminds me of the salt flats out in Utah.
I was going to say, they film a lot of it in the salt flats
and then they have this huge storm, and then the ground starts caving in around the vehicle, and the vehicle drives past it. I thought I was watching what's it like? It's like the movie 2012 where the world's literally falling apart as they're driving away. It was a lot like that. And there are lots of ads like that about all the things you can do with your vehicle and how they're so powerful and they're so capable and all of these things. And it's like, no one would make the argument that you're supposed to use your Lamborghini to drive in dangerous terrain where the ground might be collapsing. And if someone did, they wouldn't have a case to stand on, because the company would argue, no, we did that because it looked cool. And everyone knows that you're not supposed to drive your car where the ground is collapsing. Just like Remington, I think, would make the argument, yeah, we were appealing to gamers because gamers like guns, and we were reminding them of how these guns are like the military because these people like the military and they think it's cool. But we know that they know, because we never said go commit criminal acts. We just said these guns are cool, and these guns are the kinds of guns that men like, because we knew that would appeal to them. But that is very different from encouraging them to go kill people, just like Lamborghini highlighting how cool their car is and how powerful it is very different from them encouraging you should drive it in an unsafe way.
Yes, that despite the fact that they're maybe showing it as offensive rather than defensive, that is a far cry from
encouraging those acts,
encouraging a crime. In fact, there are cases where using it offensively, depending on what you mean by offense, would be legitimate defense of someone else, or legitimate defense of or you're in a situation where you're under some kind of foreign attack or something like that, and you're using it offensively against the enemy. There's even to say that you're going to use the gun offensively is not necessarily counter to self-defense, per se, in terms of what the legal right is.
And that is a reasonable argument that lots of people who own firearms do own them with the idea that if the country was ever invaded, they could grab their guns and become Red Dawn, if like necessary. The movie. Yeah, exactly.
Yes.
And so having advertising that keys into that demographic and those ideas is good advertising, but it is very different from encouraging criminal acts. But because these two groups are so different, you know what I mean? These NRA gun-toting individuals are so foreign from the people who just see these assault rifles as fully automatic machine guns that could, kill millions, which, by the way, AR-15s are not. Yeah. They are not machine guns. They are not fully automatic. The difference between an AR-15 and, by the way, there are thousands of different models that aren't AR-15s that are still semi-automatic that have 223 rounds or even bigger, more destructive rounds. Yeah. There are tons of them. And so just targeting the AR-15 means that you're just targeting a style of gun versus how dangerous it is, which is strange as well.
Right. There is an alarming amount of, and this is a side issue. And if you're listening to this and you don't like guns, do yourself a favor and do your research before you do, propose bills and things like that or talk ideas, because there's a surprising amount of anti-gun stuff that can't land because it literally doesn't understand guns. Mm-hmm. Mm-hmm. It not only is it not going to take effect, even if you think it should, or what, this is aside from what you believe should be the legal
just
standard.
On a practical sense.
On a practical level, you need to know what you're talking about. And there are legislators who say things about it that you're like,
well, it's not just about talking about it, Dan. When there was the federal assault weapons ban, a couple decades ago, many of the things that were banned were cosmetic, were things like how the grip was set up. And so, of course,
it's a military style. And what they mean is appearance of military goods.
The problem is, they were like, we don't want these guns to look like military weapons, but we don't care how they function. And so, of course, as a result of that, you had a bunch of different guns that looked different, but served the exact same purpose. Yeah. Well, and it goes back, Dan, to the fact that it's, in many ways, it flies in the face of data. So, for example, this was a school shooting that was perpetrated by an AR-15. School shootings are awful and something that I think that we should take seriously.
Yes.
Changing a
grip
on an AR-15 is not going to do that. Even banning all assault rifles isn't going to do that, because of gun violence that was committed in a given year. About 3% of that was from assault rifles versus 60% that were handguns, which means even if you got rid of all rifles, you could at most take care of 40% of the problems. And then even specifically mass shootings, which everyone argues is just assault rifles, it's still only about 30% are actually committed by assault rifles. And so the majority of mass shootings, which are what assault rifles are supposedly for, the numbers don't add up. And so it again begs the question of what are the priorities, what are the goals here, and having reasonable conversations, I think, would go a long way towards more reasonable reform that people can get behind.
It's odd that this is one of those topics where you're never sure if what's being argued is, what the end goal of the person you're talking to really is. It's so often somebody arguing for assault rifle bans, or so often it seems, and I don't know how often it's the case, it seems that any gun ban is good, and it seems it's accurate that any gun ban is good if you want to get rid of all guns. Mm-hmm. Right? It's all of its progress, and and the reverse is also true. If you're in favor of a complete gun freedom, then any motion in the other direction is good. Mm-hmm. And so people will pick up on what they think the public can swallow in one direction or another. Yes, and try and move it. But then they make bad faith arguments on the particular because they don't really care about the particular. They're making, they want something broader. And so it's really hard for gun control stuff to go anywhere for some of the same reasons that it is for abortion. You get people who are like, no, guns are bad. Let's get rid of assault rifles. We can at least agree on that, right? Mm-hmm. Let's get rid of this. And it's it's a very difficult area of law. A very, very difficult area. As far as I'm concerned, this particular one, I agree with you that I don't think, if you were to say, let's discard the legal standards right now and say what would be ideal? What would, in an ideal system, would they be able to make these advertisements without being sued for culpability when someone uses one of their weapons wrongly?
Mm-hmm.
I think the answer is yes. I don't think that culpability extends so far out there that a gun company hinting at the ability to use this weapon offensively can be rightfully sued for the death of someone who's been murdered.
Well, they can be sued, but whether or not that lawsuit has any grounds, that they will win.
Yes.
Because
you always want it open to suit.
Yeah,
yes,
exactly.
yes.
And that's part of the problem with that law that I dislike about it, is the fact that it's stopping the lawsuit from even happening. Is that I don't think we should stop lawsuits from happening. I think we should have reasonable case law in place, or whatever,
so that you filter out quickly the bad ones.
Exactly. So you don't get bogged down in frivolous
you're
lawsuits,
right.
while also giving people the right to sue companies.
Yeah, there are other areas of law that come to mind as you say that, where there are major problems because you can't even begin the case.
Yeah, you can't even have the conversation, and that's a real problem.
Yeah, that's a good point.
And here's the thing: is there could be documents that could shift that. You know what I mean? If there's evidence, like right now, we're going to get a crap ton of documents from Remington.
Yes.
And maybe we're going to find in those
up.
documents that Remington executives were intentionally targeting children, young men under the age of 18 with their advertising. And that could shift, what they're going to, kind of like with cigarette companies, or more recently with vape companies, where the argument is made, hey, it sure looks like they're targeting children. And if it turns out that they intentionally are, they're willfully are, then you've got a real problem. You know what I mean?
Yes.
Then you've got...
That's different.
And that may be the case, but just on its surface, those ads alone are not enough.
That's right. The internal documents played a role in making this settlement because they got access to them in pursuit of the case.
And
so
they're
they
going
saw
to be
them,
released.
and that's why they're demanding their release. That's a good point. So there may be things released here that significantly change it, but thus far, it's our understanding that the documents only serve to reinforce what the advertising showed, which is that it was vaguely encouraging of offensive use, which is, an appeal to manliness and these things.
An appeal to manliness.
And if it only confirms
and the coolness of military things.
Yes. In our opinion, I think my opinion would be unchanged if that's all those documents show. But they could show more than that, in which point I'd certainly be willing to revise my opinions if there's something darker going on. Yeah, it's too far removed. Isn't it odd that to bring a case, you have to have standing, and their standing comes from being victims in the Sandy Hook, the families of the victims of Sandy Hook. And they're able to come to this company. It's so far removed from what I would say are the actual causes of the crime and of the things related to it. And you'd have to have something really directly tying them to it for it to make any sense to me.
Yeah,
and
that's why I brought up the documents, because if they were targeting underage boys with their advertising intentionally, that could bring it much closer to the actual shooting. You know what I mean?
Yes.
Because then there's a clear connection. Yeah. You've got this anyways, but it's
yes. It would still be weird that it's connected to the Sandy Hook shooting particularly, but it could be, but it's got to come from somewhere at that point, and that it comes from here is as good a place as any. Yeah.
And for the record, I do think that when the shooting was actually committed, it was by an adult man. I don't know how old he was, but he wasn't a kid. He was, he was like 20 or something. And so even that, I'm not sure would actually bring it closer to the Sandy Hook shooting. And I think I want to say it was it was his mother who owned the firearm. So
yes, his mother owned it.
So
he shot her before he did it.
And so those things, once again, bring it farther away from Remington. You know what I mean? That if she owned it and not him, then what does the advertising have to do with it in the first place? If they're trying to advertise to young men and the mother bought it, it does raise some questions. Unless, of course, she bought it for him and bought it before he turned 18, and that's why she bought it.
Right. If we're willing to pin this level if you're willing to take that level of distance, then why can't you sue somebody who was, I don't know, mean to the kid? Or who was, said some, went shooting with him at some point in his life, or if you're connecting dots this far back.
That's why I said at the beginning, it's because of the core belief. It's a fundamental belief.
Right. The motivation is not
that the firearms are the problem. That if we didn't have the firearms, this never would have happened.
And that a good legal standing to attack the firearms is a good case that should be pursued.
Yeah, regardless
not necessarily
of whether
because
or not
there's a causation.
Makes sense itself. Yeah. It's a broader issue that they're going after, and this is just what they're able to do today.
Mm-hmm. Well, we'll follow up on this if the documents, when the documents are released, there will probably be news articles that touch on it, and we'll mention it if it brings up anything significant. We'll mention it at the beginning of another episode addressing another topic.
And with that, thank you for listening.
Have a good one.
This has been an episode of Rethinking Politics. You can find us on all of the major podcasting apps or on YouTube. You can reach out to us at rethinkingpoliticspodcast@gmail.com, or you can visit our website at rethinkingpolitics.podbean.com, where you can support us via Patreon. Thanks, and have a wonderful day.